Hi guys, we wanted to go over a few things, what happened today in the press conference with Mayor and the AG for DC. Um, what can they do to protect themselves, and what other cities, blue cities and blue states can do to protect themselves for um, basically National Guard rolling up in there like Los Angeles. Uh, Taco has said that he was going to do it. So let's go through it. Okay, so what happened today? The judge pushes DOJ to back down. MPD chief stays in charge. At the emergency hearing, U.S. District Judge Reyes said she would issue a TRO blocking the takeover unless DOJ rewrote its directive that had named DA Administrator Terry Cole Emergency Police Commissioner. DOJ then revised the order so Cole can only request MPD services at 740, Section 740 allows, rather than command MPD. Chief Pamela Smith remains in command. Okay, the mayor, the AG, had a press conference. Okay, said the federal commissioner move was unlawful under the Home Rule Act. They confirmed the court prompted a scaling back, that the district lawsuit continues, and that the district lawsuit continues. The new federal memo on immigration cooperation, even as DOJ backed off the commissioner's claim, AG Bondi issued a new directive telling MPD to cooperate with federal immigration enforcement despite DC sanctuary policies, another point the district is contesting. Okay, National Guard remains activated. The White House emergency orders invoke 740 and mobilize the DC National Guard are still in effect separately from the commissioner's issue. Okay. Okay, so what are the next steps to unwinding the federal control and demobilizing the Guard? Okay, in court, fastest path, seeking a preliminary injunction and declaring declaratory judgment that 740 allows only temporary federal purpose requests to the mayor, not control of MPD. Bondi's immigration cooperation mandate exceeds 740 and conflicts with DC law, and any further attempt to install a federal commissioner is ultra vires. Okay, today's hearing signals that the court is receptive. Police requests must be narrowly federal. Ask the court to require that any DOJ requests, specifically the federal purpose and scope with reporting and time limits, and bar tasking MPD with general local policing under the emergency. Guard deployment, argue that the federal emergency finding is unsupported, and seek court limits on how Guard troops are used in civilian policing. Posse comitatus, we talked about that before. Constraints still matter for federal active duty. DC Guard is unique, but courts can cabin use to legitimate purposes. So in Congress, hard stop on the limit. So I'm just going to skip that because we know that Congress is not going to do anything before the midterm. So I'm just going to skip that. Okay. So that is in place for Congress to act, but we know that they're not going to act because of Taco. Okay, public record and compliance demand the required 48-hour notice to Congress, statutory requirement and written justification of special conditions of emergency nature, put DOJ to proof, build the record that 2025 crime is down, undercutting emergency claims. Okay, so what can the mayor and AG can do? What can they do under the Home Rule Act right now? Insist on the statute's limit. 740 lets the president or the AG by delegation direct the mayors to provide MPD services for federal purposes. It does not permit replacing MPD leadership or running day-to-day local policing. Keep MPD chain of command intact. Require all federal requests in writing with purpose, duration, and personnel impacts. Enforce the clock, track and mobilize the 48-hour notice to Congress and a 30-day sunset. If Congress doesn't enact an extension, demand an automatic termination of the 740 deployment and related directives on day 30. Challenge the immigration cooperative memo. Move for injunctive relief, specifically to Bondi's memo, as beyond the 740 federal purposes, scope, and contrary to DC law. Today's reporting shows that the memo is the new pressure point. Guard coordination rules. While the president controls the DC Guard, the mayor can set MPD guard coordination protocols to protect civil liberties and keep guard roles limited, traffic security parameters, not routine patrols, and document any overreach for the court. Okay, so who's in charge? Chief Pamela Smith. Okay, not DEA. Not DEA Cole, after the judge prompted DOJ rewrite that. Is 740 still in vogue? Yes, but narrowed to request to the mayor for federal purposes. Litigation on broader issues continues. Is the guard still out? Yes. Mobilization remains under the White House orders unless the court or Congress halts it. So it's only the court. We know that the Congress is not going to do anything. All right. So here are some other questions that I had. Okay, so here are, can you join federal, a court can simply order the DC National Guard off the streets just because it disagrees with the president, okay? The Guard reports to the president in DC, but courts can halt or sharply limit deployments when they violate statutes or the Constitution, and they can enjoin the federal officials who implement the president's directive. Here are some practical legal levers, because the question was, how can the court halt the National Guard in DC? Okay, so that was the question, sorry. Okay, show the deployment lacks a valid statutory basis. DC riot statute requires a request. Okay, OLC broad reading of other duties can be tested. Okay. Enjoin unlawful law enforcement roles, posse comitatus and DOD rules. Okay. This is Title 10. Okay. So if the DC National Guard or any accompanying Title 10 active duty troops are being used for search, seizure, arrest, or direct law enforcement, plaintiffs can point to the Posse Comitatus Act and implementing statutes under 10 USC 275 and DOD policy 3025-18 and DOD 3025-21 to enjoin those specific activities. Courts have recognized these limits and can bar direct participation while allowing non-policing support, traffic control perimeters, logistics, etc. Okay, so they can enjoin constitutional violations, First, Fourth, and Fifth Amendments. All right, so Lafayette Square litigation shows how federal officials, including the military personnel, can be sued over such conduct. Courts allowed significant claims to proceed and could order prospective relief. And this was 2020. Remember the Lafayette Square where Taco held the book upside down, went out there. Okay, so enjoin agencies even if the president is not removable under EPA. Okay, so the president isn't an agency under EPA, Franklin, versus Massachusetts, but courts routinely enjoin agency actions that implement presidential directives, DOD, Army orders, tasking DC National Guard using EPA arbitrary and capricious views or non-statutory ultra-vires claims practically that can stop the deployment on the ground. Seek time-boxed or tailored relief. So courts apply the Winter versus NRDC preliminary injunction test, likely success on the merits, likely irreparable harm, equities and public interest, national security, public order arguments, set deference. So remedies are often narrowly tailored, i.e. no arrest, searches by troops, no crowd dispersal missions, preserve MPD control of incident command. Distinguished from the police takeover rules, the Home Rule Act Section 740 keeps federal control of MPD, 48-hour notice to Congress, 30-day limit, unless extended by joint resolution. Courts can enforce those limits against the police takeover, but 740 does not itself authorize or limit National Guard deployments. Guard authority mainly runs through the DC military code discussed above. Still, a judge can police any attempt to bootstrap Guard missions off and overboard of 740 federal purpose theory. Okay, what this looks like in court. Who sues? The district, mayor and AG, impacts residents, protesters, civil rights groups. Whom do they sue? DOD, the Secretary, the Army, DC, National Guard, Commanding General. Okay, DOJ, Department of Homeland Security. If they're directed missions, seeking to enjoin them from carrying out unlawful orders. You don't need to enjoin the president personally to stop the machinery. Okay, what evidence? Mission orders, status of forces, Title 10 versus militia, absence of valid 49103 requests, examples of direct law enforcement conduct, arrests, searches, and any right violations on the ground. So the bottom line is the court can't mismanage public order strategy, but it can halt the DC Guard deployment or strip it of policing roles. Okay? By finding one, no valid 49103, predicate or misuse of 49102, violations of posse comitatus, DOD rules for Title 10 forces, constitutional violations, and then enjoining agencies and officers executing the missions. That's a realistic path to stopping the National Guard involvement in DC policing. Okay, so then I ask, okay, what can these other states do? So what can other states do? Well, Washington can and cannot do. Federalized state guard under specific statutes, Insurrection Act, okay, 10 USC 12406. When federal law can be executed when regular forces, these require real findings, rebellion, inability to enforce the laws, not just policing disagreement. Okay. So U.S. federal agents, DOJ, Homeland Security, and active troops, active duty forces face strict limits under posse comitatus and DOD policy. Here's a preemptive guardrails to adopt now. This is what they can do now. Lock in anti-commandeering statutes that bar state and local officers from being required to enforce federal programs, immigration, protest control. The Supreme Court's anti-commandeering cases, Prince and Murphy, back you up, and you can decline to use special state resources for federal ends. Condition all joint ops on written MOUs. Okay? Tighten cross deputation, prohibiting and narrowing cabin cross deputizing locals as federal task force officers unless federal partners accept your use of force, BWC, and disclosure rules. Okay? Guard posture plan. Draft orders to keep your National Guard on state active duty, Title 32, for civil support missions under the state control. Spell out missions that avoid direct participation in law enforcement. So if Washington tries to federalize, the record shows that state capacity and compliance. Okay? So PCA, DOD rules forbid using federal troops to do arrests, seizures. Don't create a workaround. Standing litigation package. Have a TRO, PI, a preliminary injunction papers ready. That challenge any insurrection act or 12406 invocation of ultra vires, arbitrary on the facts, in joint agencies like DOD, Army, DOJ, Department of Homeland Security that implement the orders. That the president isn't an agency, but implementing orders are reviewable and seek tailored relief, barring direct law enforcement roles by federal forces. Legislative oversight and data. Okay, require real-time reporting from state and local police on crowd control actions, mandate publication of incident command structures during emergency to show courts that there's no breakdown justifying federalization. Courts have reviewed and curtailed martial law claims before Sterling versus Constantine. For cities, mayors, and councils, especially inside red states, non-cooperation ordinance, local crowd management rules, evidence pipeline, mutual aid that preserves local control. So if the White House announced a deployment, immediate court moves, state AG and city with state AG aid, file a TRO preliminary injunction against the DOD, Army, DHS, DOJ, if applicable. okay, to bar federal troops' direct law enforcement roles. Okay. Demand the statutory finding that the trigger that the Insurrection Act of 12406 and attack them factually, not no rebellion. Laws can be executed. Laws are intact. Local law, local order intact. Courts do not review pretext. Cite Sterling and the general separation of powers. Youngstown logic. Tailor relief, even if the judge won't send the guard home, they often strip roles. No arrest, searches, no joint command over locals, which neutralizes the practical impact. Operational steps, same day, publish your incident command chart, okay? Who's in charge, state, local, okay, curfews, escalation, blah, blah, blah. Deprive Washington of the chaos predicate that is required for the Insurrection Act relies on, okay? So order local agencies to decline tasking from federal teams that would violate state, city, BWC 4 standards, document refusal, and anti-commandeering. Why this works? The anti-commandeering rule lets states and cities withhold their own resources from federal initiatives. Pritz and Murphy are the anchors. The Posse Comitatus and DOD's own rules make it unlawful for federal troops to do ordinary policing. Courts routinely adjourn agencies executing presidential directive when those directives overstep statutes. Courts have historically checked emergency theatrics. They review whether insurrection emergency findings match reality and can pare back deployments to logistically only support. Sterling versus Constantine is the classic example. Okay, so that's it. All right, so hopefully this helped.